Good afternoon, Monica Miller here. This is Legal Tuesdays, where I answer your questions about separation of church and state that you've asked for us on our social media platforms, as well as our new Legal Tuesday online form if you prefer to use that. The first question is from Nan Wizov using our Legal Tuesday form online, and she says that just in case she's ever in a situation where it's required for me to place my hand on a Bible to ensure the information I'm going to share is truthful, are there other means by which a humanist can commit to truth other than swearing on a Bible? Absolutely. You have an unequivocal right as a citizen here in the United States to never have to have the government compel you to affirm or swear or profess any belief in a higher power, a God, a Christian Bible, all of that completely. They might have that as the offering. So I think in state courts, especially many state courts, maybe in the South, use a Bible to swear in witnesses. You have a right to say, I will not do that, and I would prefer to affirm rather than to swear or use an oath that contains God. There was a good Supreme Court case in the 60s, Torcaso versus Watkins, where the court made it abundantly clear that no government entity in this country can require a person to profess a belief in God, whether it's that particular case involved an atheist who wanted to become a notary public in Maryland, and Maryland's Constitution has a provision in it that basically says in order to become a member of any sort of public office, you have to affirm a belief in a higher power, and the Supreme Court unanimously, either it was unanimous or it was 8-1, but very close to unanimous, struck that provision down and said it is unconstitutional to require an atheist or anyone else to believe in a higher power or say that you do. That's coercive and it's unconstitutional. It doesn't just violate the Establishment Clause of the First Amendment, it actually also violates the Free Exercise Clause of the First Amendment, and there's also a Religious Test Clause that it very comes close to violating. I don't know if the Bible situation would, but that's in many ways more egregious. So if this ever does come up for anyone, please call us. I've dealt with several of these issues, and all of them I've resolved via letter because it is just such a clear-cut issue for us. And one was a naturalization application where the person was forced to say an oath that included God, and then the other one was an Air Force enlistee who was also forced to do an oath that had God in it. It's we've slowly been working on trying to just get the forms completely changed where you don't have to opt out of the God language, and some states and federal district courts don't have that, say for an attorney form, because I've had to do a lot of these for attorney forms. And luckily, I'd say over half of the ones I've had to fill out do not have any God language in them. I just affirm, that I'm going to tell the truth or whatever the thing is, and we're good to go. So definitely never should you ever have to swear on a Bible or even believe in God to testify or anything court related. The next question is also an email submission from our Legal Tuesday form, and it is from Bob Ritter, who quotes the Establishment Clause of the First Amendment and then says, what is the proper test for evaluating an alleged Establishment Clause violation? 1 is strict separation of government and religion, 2 is the Lemon Test, 3 is neutrality, and 4 is legal judgment, which was a term by Justice Breyer. So I will start here with saying, there's a lot here. I'm going to start by saying that number 3, neutrality, isn't really a test, so we can knock that one out. Neutrality is a concept that sort of undergirds the entire church-state separation of the Establishment Clause. It's the idea that government has to be neutral when it comes to religion. It has to be neutral with respect to religion and non-religion, and it has to be neutral with respect to different religions. So it can't prefer Judaism to Christianity. It can't prefer God belief to atheism, and so forth. So that's a standard, it's a principle, and it's necessary, but that's not really a test that the courts can use. It doesn't provide the courts with sort of an analysis. If you're a lower federal court judge and you get a case involving a Ten Commandments monument, neutrality doesn't really answer that question for them. So similarly, the first question, strict separation between government and religion, that's also one that is a standard, it is a goal, it is what Thomas Jefferson meant when he said there's a wall of separation between church and state. I think all governments in our country, state, local, federal, should all aspire for the strictest separation because it benefits both religion as well as non-religion, atheists. I actually think it benefits religion in many ways more than atheists to have that separation. Nonetheless, it's also, like neutrality, a principle, and it's not really an analytical test. Very similarly, Justice Breyer's legal judgment test that comes out of his concurrence in Van Orden versus Perry, 2000's case involving a monument, is about as useless as a test goes. He basically said it. No one agreed with him, despite his concurrence in that case being controlling just by the way the votes shook out. Lower federal courts have looked at what he wrote and kind of have balked at it. I mean, there's law review articles saying, what does Justice Breyer mean by legal judgment? Isn't that what we're hired to do as judges, is use our legal judgment, but we need a standard or a test. I mean, it's like no lawyer wants to be before a judge who's just going to create his own standard that day. So it really doesn't make sense. Maybe at the Supreme Court level where they can just basically do whatever they want, but the lower federal courts are tasked with interpreting the Supreme Court's cases and applying them. And so when you've got a case that says, just use your best judgment, does it violate the Establishment Clause? I don't know. I mean, there's no even connection to the original intent of the framers when you go in that direction. So that really leaves the Lemon Test. And what I find so interesting about this is that this last year, I argued before the Supreme Court, and at issue was the Lemon Test. And my opponents, I had two opponents. I had the government, the Maryland government, and then I had the American Legion that was represented by conservative Christian religious right group and attorneys. And they wanted to decimate the establishment with the Lemon Test. Now, the Lemon Test is very straightforward. It is this idea. There's three kind of concepts to it. It's that the government has to act with a secular purpose. It cannot be motivated by advancing religion. Two, the effect of the government's actions must not be to advance or endorse religion. And third, that the government cannot excessively entangle itself with religion. Now, the case is born out of the test is born out of a case from the 1970s called Lemon versus Kurtzman. But even in that case, the court says this is just us distilling decades of jurisprudence. This is what the Establishment Clause means. It means the government has to be secular in these different ways. This is how we can measure that. We can look at purpose. If the purpose of the government's actions are to advance religion, whether those efforts are successful or not really doesn't matter. We can't have a government hell-bent on establishing, Catholicism. And so even let's just say that a very unpopular politician, uses a Catholic church to hold a big prayer event, but he's doing it with, taxpayer dollars. Let's just say this person's so repulsive, like no one likes this politician, and it ends up driving people out of, away from Catholicism, and no one, people leave the church and come to humanism. So the effect of the action actually did not advance or endorse religion. However, that was the intention behind the action, and therefore that violates church-state separation. More of the cases fall into the effect prong, because very rarely does the government act with a purpose to endorse religion and then not succeed on some level in doing that. But most of our cases, because proving government intent is very hard just from an evidentiary standpoint, because you've got a bunch of different actors and they can say different things, and sometimes they don't put into writing what their purpose is. So we usually end up in an effect prong world. And the Supreme Court, it's always looked at purpose and effect. I mean, I read every single Establishment Clause case from the beginning till present, when I was preparing for my Supreme Court case. And I think I counted somewhere in the ballpark of 10 to 15 pre-Lemon cases where the court relied on the purpose and effect analysis. And it is an analysis. It gives the courts benchmarks to look at. There's case law there. And ultimately, in my case, the court did not overrule the Lemon Test. In fact, even though there's language in the majority opinion, somewhat, or plurality rather, it's a little nuanced there, but purporting to criticize the Lemon Test, ultimately the court, majority, plurality, and concurrences all look to the purpose and the effect of the government's actions, and ultimately the majority of the justices concluded that the cross at issue simply was more secular than it was religious, but that was vis-a-vis measuring the purpose behind how it got there, as well as the ultimate effect it still has today. So to me, purpose and effect, you really can't get rid of them. People have tried, our opponents have tried, and it survives for a reason, because it's the best test that exists, because I think it's the closest, it tracks the closest to the original meaning of the Establishment Clause. Well, that is way over my time, but I look forward to talking to you next time on Legal Tuesdays.